Alright folks, this is our second video going with the course of Law and Society in the fall of 2020, and in this video I particularly want to go over a handout that I have put in your materials, which is called Supreme Court Terminology. We talked in the last lecture about the Constitution, how it came into being, what its broad purposes and ideas are. And now I want to talk a little bit more specifically about how the Supreme Court works, because again, we're going to be going over a number of Supreme Court cases and decisions as part of discussing the various topics in the rest of the course. The first thing that I don't believe is in the handout, but that you need to be aware of, is an idea that comes to us from British law. It's been part of the British court system for hundreds of years, possibly as long as 1,000 years, and it was so much a part of the British system that the American colonies incorporated it into their court system, and when it became time to write the Constitution, to create the federal judiciary, they didn't even talk about this idea, this concept, because it was so much a part of their jurisprudence and their legal operations that it was just presumed, it was assumed that this would become part of the law it would carry on. And in a great reality, and to a great extent, the American Revolution was not a social or economic revolution. It was a political revolution where we basically put out one sovereign, the King of England and the English Parliament, and replaced it with another sovereign of our own making, a federal government controlled and regulated by a constitution. The economics of the colonies did not change after the Revolution. The society, the social structure, the religious structure of the colonies did not change after the Revolution. This is greatly different from the French Revolution that came a few years after the American Revolution, where the structure of French society was basically demolished and destroyed and gave way to despotism and tyranny and the terror. We all have pictures in our mind of the guillotine, which was seen as a humane way of executing people. And if you've read Dickens' Tale of Two Cities, you have the vision of Madame Dufarge sitting every day on the what's now the Place de Concorde, happily knitting away, watching hundreds of people a day come to their death, having their heads chopped off by the Republican government of the Revolution because they were somehow part of the old aristocratic class, or they were somehow counter-revolutionaries or did not have the right thought process. And as we went forward into the 20th century, certainly the communist revolutions, the Bolshevik Revolution in Russia, the communist revolution in China, the revolution instituted by the Pol Pot regime in Cambodia were all revolutions of the same type, where not only were they seeking to change the form of government, but the people in control of these revolutions who came to power sought to dismantle the entire structure of society, economics, and culture, and to rebuild them in their own image. That did not happen in the American Revolution. As a matter of fact, it so much did not happen that in the state of Rhode Island, which had operated under a charter from the King of England from the time of Roger Williams, its founder, up until the end of the Revolutionary War. When the war was over, they pulled out the charter from its drawer, they crossed out the King of England, and they wrote in the people of the state of Rhode Island, put the charter back in the drawer, and for another 30 or 40 years, it continued to be the ruling government document of the state of Rhode Island. So there was so little change in the culture, in the legal system, the court system, that basically you still had an English society. You still had English laws and English rules governing here. And to a certain extent, that is carried through to the present day. Now, this basic idea that I want to talk about is an idea called precedent. Precedent in the English court system was the concept that once a court has heard a fact pattern, once they've made a decision on a specific issue, they are bound to come up with the same decision whenever that issue arises again. The idea here is stability and consistency, that you cannot have the courts deciding an issue one way this week and then deciding it a different way the next week, that If courts do that, if they are inconsistent, if they are illogical in their processes, that the law cannot exist, that all we'll be creating is chaos, that no one will be able to know what the law is, and that the people will eventually come to resent that and will rebel against that. And again, the English judges very early built this idea into the English court system. So it was hundreds of years old by the time the colonists revolted from England and set up their own government and set up the Supreme Court. So, needless to say, the Supreme Court, being a court created in the English idea and model of courts, it assumed that it would go forward endorsing and utilizing the idea of precedent. And this became particularly important because early on in its history, in the case of Marbury versus Madison, the Supreme Court took to itself the power to interpret the Constitution and to tell the other branches of government what the Constitution means and what they could or could not do under the Constitution. And once that was entered into the law books as a decision, it became precedent. And it is still precedent today. It is a rule that is still followed. So whenever we're talking about the courts, whenever we're talking about decisions of a court, we constantly, as lawyers, have to look back at what did the court say about this issue before. Even if we come up with some marvelous, amazing, tremendous argument about why things should be different, we have the weight of this idea of precedent that, well, your theories are really nice, Attorney Walsh. However, we cannot support them, we cannot endorse them or utilize them at this moment because precedent in this prior case from 5 years ago tells us what the decision should be in this case on this set of facts, which is the same as the set of facts in the previous decision. Now, I suppose I should back up a little bit and make it clear to everybody what is the role of the court. The courts in our system have a very distinct role. They are to hear arguments. They are to hear contests of ideas, contests of views, contests of rights, and to make a decision. Right? The Constitution is clear. It says that the federal courts are only to engage in cases and controversies. And the court has took that to mean that they can only make decisions. They can only make pronouncements on actual issues, actual arguments between real litigants, between real people that are brought before them. You do not see the Supreme Court justices going on TV and making statements saying that, well, we really don't like the tax code, so next year we're going to take a bunch of tax cases and we're going to make dramatic changes to the tax code because, my God, Congress has mucked it up and they're not doing anything to fix it, so we're going to get involved. The Supreme Court, based on this idea of cases and controversy, does not and cannot do that. They must wait for real litigants, real parties with a real issue to bring a case before them, and then they can make an issue on that argument and on nothing else. So what has happened over the years is that by this system, legal theories have developed. The Supreme Court has made its decisions on many issues that affect our lives, but they basically come about slowly, and they come about always with the idea of looking at, well, what did the court do in the past? And we have to acknowledge that and give some reality to that. It is very rare where the court will come out and say that a prior precedent was completely wrong and we're completely overturning it, and it is done, although it has done that on some very important occasions. Brown versus the Board of Education, which abolished segregation by race or ethnicity in schools, was one of those decisions that did that. But those decisions, even today, are still few and far between. They are rare. Now, having said that, let's talk about some of the Supreme Court terms. I'm going to keep looking down here to make sure I go over the list, so please don't be put off by the technical lack of ability in these tapes and these videos. First and foremost, the Supreme Court does not have to hear every case. There is certain jurisdiction that is set out by the Constitution, but for the large part of their jurisdiction, they have what is basically called voluntary jurisdiction. They can determine if they're going to take a case or not. There is no guarantee that your case is ever going to get to the Supreme Court. in order to get to the court, you basically first have to go through all the lower court systems on either a state or the federal level. And then when you've used up all of those remedies, you file something called a writ of certiorari. And that is a Latin word, and it basically means to take up or to look at or to review. And so when you file a writ of certiorari, you are requesting that the Supreme Court hear your case, that they take it under consideration. The Supreme Court gets thousands of writs of certiorari every year at this point, and they actually hear only several hundred cases, if that, in any given year. So it's rare that a case actually gets to the Supreme Court because of this idea that they do not have to take every case. They can pick and choose what they want to hear. Now, an opinion. When you read in the literature something called an opinion, that is the decision of the court. It's sometimes also called a majority opinion because the court is presently made up of 9 members. They hear cases, they hear the oral arguments, they get all the written briefs and memorandums, they study the law, they have their clerks do research and come up with ideas, and then they vote on how they are going to rule, and the majority, of course, wins. So 5 votes are all that takes for a decision to be handed down, and that decision will be called the majority opinion or the opinion of the court. Now, those judges who vote against that decision, and many decisions in recent years have been 5-4 decisions. The court is somewhat ideologically divided at this point in time, and so you constantly have these decisions coming up where it's a 5-4 thing. The 4 justices that lose, they are not silent. They also write opinions. These are called dissenting opinions. So the judges who voted against the case are allowed to write up their reasons why they would have handled the case differently. These are important to lawyers because particularly in an atmosphere you have a 5-4 decision, even though precedent comes into play, if you know that it only takes one more judge to convince to go your way on an issue, and you have the reasoning and the thoughts laid out of the 4 judges who already voted against a certain proposition, it becomes very helpful in crafting your arguments, crafting your written documentation that you're going to give to the court in any case. So they are important. Sometimes there are also concurring opinions. A concurring opinion is where of the majority justices, they all agreed the case should be decided this way. However, they have different reasons as to their decision. So sometimes a judge will say, well, I agree with the majority, but their thinking, their thought process, their legal analysis is all washed up on this. Here's how I came to the same decision as these other folks. And again, very helpful to lawyers to try and analyze the thinking of the court and to review what are basically the court itself laying out different ways of looking at an issue, different ways of arguing an issue. A per curiam opinion or decision is a decision made by the court as a whole. Very often it is handed out and it does not even have a particular author. Almost all decisions, even if there are no dissents or concurring opinions, the whatever judge wrote the opinion, their name will appear so you know who it is. A per curiam opinion is a decision reached by the whole court unanimously, and very often it will not even have the author's name stated. And these are very often reserved for cases where the court wants to make it very clear that we are all united on this idea. You're not going to talk us out of it, and the other branches of government better go along because this is our final decision. There's no dissent. We are united, and we're not even going to let you know who it is that wrote the decision because we all agree with this. To uphold means the Supreme Court looked at what the lower courts did and they approve it and they decide to go along with that. So whatever the lower court decided will be what stands in the case and becomes the decision. To overturn means the Supreme Court looked at what the lower courts did and did not like it, did not agree with it. So now they're undoing the decisions of the lower court to replace it with their own. And a remand means that they found something wrong with the lower court decision, but they're not ready to just strike it out and write their own decision, but they're sending the whole matter back to the lower courts. Very often this occurs in situations where a case comes up to them and they believe that there's insufficient information, there's not enough evidence, that arguments are not clearly stated, and that if they made a decision, they'd be kind of making it into the void without everything required before them. And in that case, they can send a case back to the court for further testimony, further evidence to be gathered, for further briefs and writings and arguments to be placed on the record. They can also uphold in part or overturn in part. Legal decisions in the late 20th century and now in the beginning of the 21st century have become long, convoluted, torturous things running pages and pages and pages and pages. I personally think the courts think way too highly of themselves and are basically subjecting us to this incredible amount of verbiage that is unnecessary. However, it is the present reality. So you very often have situations where the lower courts will meander on through a subject or subjects for pages and pages and pages, and the Supreme Court will agree with part of that, it will disagree with part of that. And so in such a situation, they can actually hand down a decision that says we uphold the lower court in part, but we oppose or we remand what happened in part. A remedy is a redress for a legal wrong. All right? It is an attempt to make whole somebody who has been wrongly injured or who has been deprived of their rights. And that is basically what the courts do, is they make a decision and they then have the power to issue a remedy. So when they decide that somebody has been injured, financially hurt, physically hurt, or when somebody's rights have been taken away, they not only make a statement saying that yes, that happens, but within their power is the ability to fashion a remedy, to order restitution be made, to order the damages be paid, to order that an injunction be put in place to prevent the violation of rights from continuing in the future. Habeas corpus is a writ, a petition that can be filed with any court. Again, it is a very ancient petition that comes from the English court system. It's probably about 1,000 years old. It is a Latin term. It means to have the body. And what a habeas corpus is, it is the power of any court to issue an order to a jailer, to a person who is holding another person, whether that be in criminal jail or in some type of civil confinement, to order the person overseeing the confinement to bring the body of the confined person, the jailed person, to be present in court so the court can investigate to make sure that the terms of this confinement or this jailing are proper and just and are legal. Incredibly powerful because it basically gives the courts the power to inject themselves into any governmental or criminal proceedings where individual liberties or rights or freedoms are being curtailed, and particularly where people are being locked up, either, again, civilly or criminally. All right. Constitutional. When we say something is constitutional, we mean that it is in accord with the statements and ideas stated in the Constitution, that it falls within the separation of powers and within the checks and balances, and that it does not in any way contradict the actual written black letter law of the Constitution, or today the intent or the ideas behind the Constitution. A brief is a legal memorandum written by the attorneys for the court, setting out their side, their positions, their arguments. Jurisdiction. It's a very important concept, and one that a number of lawyers and law professors seem to have a great deal of difficulty defining. Students go crazy both in college and in law school trying to figure it out. It's actually very simple at its core. Jurisdiction is the power and authority of the court to hear a case and to hand down a binding decision. Now, not every court has jurisdiction in every matter. You cannot get a divorce in federal district court. Divorce jurisdiction is, number one, first given to the states. And in states like Massachusetts and Rhode Island, the legislature has further taken jurisdiction over divorces and placed it in particular courts. There is a family court in Rhode Island that hears divorce cases, among other types of cases. And in Massachusetts, the probate courts hear divorces. So even in Rhode Island or Massachusetts, Even though the state has ultimate jurisdiction over the issue of divorce, you could try to go into the superior court in those states, and those judges will put you out saying, we don't have jurisdiction. The legislature has given the power to hear that type of case and hand down a decision to the family court or to the probate court. So again, at its simplest term, jurisdiction is the idea that a court has the power to hear a case and to hand down a binding decision. Now, this jurisdiction, it takes in certain aspects. One is territory. Certainly the courts of Massachusetts cannot hand down a decision about a Rhode Island matter or vice versa. So there is jurisdiction based on territory. There is jurisdiction based on subject matter. As I said, divorces must be heard in the family court. Workers' compensation cases are heard in the workers' compensation court. Cases having to do with ships on the open ocean on the federal level are heard in the admiralty courts. Certain tax matters are heard on appeal in the tax court, so that there can be subject matter jurisdiction. And then finally, there is jurisdiction over the parties. There has to be a certain connectedness between the individuals coming before the court and the court itself. A person who has a case against a Rhode Islander who has never left the state, never done anything outside the state, has no business contacts out of the state, even though a person might have a valid case against a Rhode Islander in Rhode Island state courts or federal courts, they cannot go to California in the state court and bring a case against that person, because if the Rhode Islander has no connections to California, California has no jurisdiction over their person. So this is where jurisdiction gets complicated, is in trying to ferret out what is the subject matter, what are the various courts allowed to hear, what is their territorial jurisdiction, how does federal jurisdiction play up against state jurisdiction, and then what persons do we actually have power over, what persons are connected to us. But all of those things go into jurisdiction. Again, for your sake, keep it at the simple concept, though, of it is the power of the court to hear a case and hand down a binding decision. Appellate jurisdiction. In all states and on the federal level, we have basic courts. On the federal level, they are the district courts. In Rhode Island, they are the district and superior courts. Again, in Massachusetts, they are district and superior courts, where there are witnesses, the courts take testimony, they gather evidence, they hear arguments. In many situations, there are juries who vote. Those are the workhorses, those are the everyday parts of the court system. If you do not like the decision that came out in that court, if you feel the judge or the jury or both made an incorrect decision, then all states in the federal system have what are called appellate courts. Courts where you can ask that your case be reviewed and possibly have the decision overturned. And of course, the ultimate appeals court is the Supreme Court itself. Appellate jurisdiction is the idea that certain courts are set up not to hear cases in the first instance, but after those cases have been decided in the lower courts, to then review what had happened and to determine if the lower courts had acted correctly. On a federal level, there are circuit courts of appeal that are the mid-level courts, and very often cases will get to the circuit courts of appeal. You'll try to, from there, go by certiorari to the Supreme Court, and that will not happen. So the circuit courts of appeal in the United States have tremendous powers, because very often they are the last court that is going to consider a case, considering an issue. A docket is a list of cases scheduled to be heard by the court, and it also the means by which the court keeps track of the cases. Every court assigns numbers to the cases. When the decisions are issued, not only do they have a docket number, but they are published in a volume and they are given a book and page number. So there's basically a system by way of dockets and by way of case citations that allows any person to look up any case and to find what was written, and to read about it. Federal question. Again, certain things are left to the state governments, and certain things are given by the Constitution to the federal system. The Supreme Court and the federal courts can only hear issues that concern federal questions. Now, through the 14th Amendment, the idea of a federal question has become tremendously broad, because the 14th Amendment, if you remember from our last lecture, says that every citizen of a state is a citizen of the country, also of the United States, and that no state can withhold equal protection of the law or due process of law from any citizen. So the idea of what is a federal question was tremendously increased, probably 1,000-fold from what it was prior to the enactment of the 14th Amendment after the Civil War to today, where it seems that the federal courts are involved in everything, but that is not true. You still cannot get your divorce in federal court, and unless your former spouse raises constitutional issues, there's no reason for your case to ever get into the federal court. You could appeal it within your state court system, but the Supreme Court of your state would be as high as you could go, and there would be no further means of having your case heard. So only cases that involve some type of federal question, either something deliberately given to Congress or the executive by the Constitution, or something where the states are violating a citizen's rights under the 14th Amendment, are cases that actually are supposed to get into the federal system. Standing. Now, the next few things, the courts initially took a view that the Constitution limited their powers. And that was the whole idea of the Constitution, that it was supposed to limit the powers of government, of this federal government. And the Supreme Court took this idea on very early and held it for a very long time, right up into the middle of the 20th century, at which point they began to let go of some of these concepts. But these concepts are still here, and every now and then, if they don't want to handle a certain issue, they will fall back on these concepts to find a quick and kind of easy way of getting rid of a case without making an actual decision on the issues. So the next few things we're going to talk about have to do with ways the court limits its own power. The first way that they limit their power is that they require every person coming before the court to have standing. Standing is the idea that only the person whose rights are involved, whose injuries are involved, have the right to bring the case. So that if your car is totaled by a drunk driver and you decide not to file suit against them, not to make a claim against them, your best friend cannot file suit on your behalf and make a claim for you. The right to recover for those injuries is personal to you, and only you have standing to get into court to bring that case. No third party can do it unless they're actually, somehow you have given them power of attorney, you have basically told them to go do it in your behalf. But if you don't do that, no well-wisher who actually has your good intentions at heart, they cannot bring the case for you. So the first thing that the federal courts and the Supreme Court will do is that they will examine standing. They will look at the people coming before them and say, wait a minute, are your rights really at issue here? And if they're not your rights, they're the rights of somebody else, out you go. Have that person whose rights have been violated, who has been injured, have them come before us. Moot or mootness is the idea that an issue is no longer relevant. If the issues in the case have already resolved themselves one way or another, then the court should not hand down a decision. It is irrelevant at that point. Reality has already taken over and resolved the decision. This actually prevented voting right cases and the abortion cases from coming before the courts for a very long time, because the court process is slow, litigation takes a long time, and in a voting rights case, if you are denied the right to vote in a certain election, that election was held and is done and is long gone and over. Maybe several election cycles are done before your case gets to court. So in the early days, the federal courts would say, oh, it's moot, we can't hear this, and the same thing with abortion. It only takes 9 months for a child to be born. It takes more than 9 months to get a case through federal court in most instances. And so in the early challenges to state abortion laws, the lower federal courts were putting them out, putting the litigants out, saying, nope, sorry, the baby's already been born, there's no longer an issue. Beginning with the civil rights cases in the 1960s and 70s, the Supreme Court began to cut out a big exception to mootness and say that in situations, fact patterns that are capable of repetition, of appearing constantly, but never being able to be reviewed because the facts come up and go away so quickly, that in those cases the courts have the power to waive the concept of being moot. and to actually hear a case, even though it may have, in the practical, physical universe, resolved itself. The legal issues are still important and will be coming up again with other litigants and other people continuously. So therefore, the courts have the right to continue forward to come to a decision. A political question. The Constitution, again, divides the governmental structure into three distinct branches, gives each branch certain areas that they are in control of, that they have power over, and the courts initially took the position that certain things had to be left to the Congress or to the executive, and that we will not become involved. Particularly in determining the outcome of elections, how elections were structured, what happened in elections, the court for a very long time refused to become involved. There is a Rhode Island case, Luther v. Borden, that goes back to the early 1800s. There actually was a small revolution in Rhode Island in the 1820s. Up until that point, the government was controlled by allowing only landowners to become voters, and the vast majority of people in those days were not landowners, so the government was controlled by a very small group of people who were mostly descended from the old-time Protestant Yankees that had first come to Rhode Island in the 1600s. So basically, a few families controlled the entire apparatus of state government. And as the Industrial Revolution hit, mills began to be built, and immigrants began to come in from Quebec and Ireland and other parts of Europe, there began political tensions to arise, and eventually there was a situation where a group of people held a separate constitutional convention, put up a separate slate of state officers, and for a period of time there were two governors of the state of Rhode Island. There were two conflicting governments. In Luther v. Borden, the litigants basically asked the Supreme Court to decide which of these governments were the correct government of the state of Rhode Island, and the Supreme Court backed off, saying, nope, that's a political question to be decided by the people of the state of Rhode Island. We're not going there. That rule was followed for a very long time, although it came into question in the year 2000 in the election of George Bush versus Al Gore, and the case that arose from that. And we will, in our next series of lectures, in our next set of topics, we'll talk about the political question doctrine and what happened in Bush versus Gore. And many people still decry the result in that case and said that the Supreme Court there basically stepped out of its role and picked a president. Who was not elected by a majority of the voters of the United States. But we'll leave that for the next lecture. We'll get into that in more detail there. Judicial restraint is the idea that the court should only act when they absolutely have to act. If there is some way to send the matter back to a lower court, if there is some way to send the matter to the legislature to make a decision, if there is some way to get out of hearing this case, and that's what we should do, and that, again, we should only take actual cases and controversies that can't be otherwise resolved, and we should limit our power. That is the ancient and older view of how the courts operate. It has been jettisoned by many jurists, many judges, many law professors and theorists in this period of time, in our present time, and more common today is to see that judges and lawyers take a position calling for judicial activism, where it is up to the court to actively engage themselves in issues, to hand down precedent that basically creates new law, to take control and to help shape and change the law, and thereby change society, and that is part and parcel what the court should be doing and actively engaged in. That is a relatively modern concept, again, evolving over the last 60 or 70 years, maybe the last 100 years, but only to become actually practiced in the last 60 or 70 years. And among legal professors and legal theorists, there is great debate today over which is the proper role of the court, to hold and only to act with restraint and as minimally as possible, or to be judicially active and to interject themselves into as many issues and conflicts in society as possible. I don't think that question will be answered in my lifetime. It probably won't be answered in yours. It has become an ongoing point of contention in our system at this time. Precedent, we talked about that at the beginning, so I'm not going to go over it again. A class action. Beginning in the 20th century, the mid-20th century, the courts recognized that there are situations, particularly when we're dealing with mass consumer products, that there may be thousands or millions of litigants with the same issue. And in order to save time and expense, the courts have allowed a process whereby every litigant with a certain issue can be brought into one case. That is called a class action. There are very definite rules and procedures about how you certify a class, how you get a case to be taken up to represent a class of people. But it has become a very popular way for lawyers, particularly to come up against large corporations that have created some product or some good or some service that have injured a large number of people, and those people now all are seeking redress for their injuries. An amicus curiae is Latin for friend of the court. The Supreme Court in particular, on issues of great public and social significance, will not only hear the arguments of two sides on the theory that each side has its own bone to pick, and that even with two sides we may not be getting the whole picture, the whole view of the law, of the social reality here. The court will ask and will allow outsiders, third parties, to file briefs. Now, they don't usually allow third parties to argue, and these third parties don't have standing, but they will be allowed to present legal argumentation to the courts to assist the court in finding the correct answer to these particular situations. Dicta. As I said a few minutes ago, one of the realities of modern judges and modern courts is that they love to write. They write pages and pages and pages and pages of things. Very often what they write is far in excess of what needs to be written to hand down the decision and to actually make a statement about what is the issue before them. Don't mind that man in the background. I'm still learning how to do this distance learning, and if you can see from my dining room, I live in a 125-year-old house. It was not set up to be a studio, a recording studio, but we are making the best we can until we come up with additional resources here. Dicta is language in a case that has nothing to do with the decision in the case. The only thing that is actually a precedent is the language that explains how the court got to its decision. And truly, really, only the actual decision itself is the precedent. But again, that doesn't stop the judges very often from going on for pages and pages and pages about all kinds of other things surrounding the issue at hand. All of that other language is what the law professors call dicta. It is nice, but it is not the issue. And as a law student, one of the things that you constantly have to watch out for, and it's very difficult to tell initially until you've studied an area in some depth, is this the real core of the decision, or is this just the judge spouting off their opinion? And very often, their opinions are very slanted, one side or the other. They make great quotations that you want to stick in a later brief or another case on the same issue. However, if it is just the judge spouting out off their opinion and is not actually part of the decision, you can quote that, but it's going to very quickly be shot down by the other side and by the court by saying, wait a minute, Attorney Walsh, that's all well and good, but that was not what the decision on the case was based on. That was just the judge going on and stating their opinion about other extraneous issues, and it really has no legal control here. It has no legal precedent. So, contrasting with the idea of precedent that we have to follow what the court said in a prior case, we also have to take into consideration how much of that was dicta, how much of that was fluff, how much of that was just opinionating by the judge, and make sure that we're not basing our arguments and our briefs on just the opinion. All right, I think that covers all of our Supreme Court terms. So that will be the ending of this video. Be on watch, go back into Blackboard every few days, because now that I'm up and running, I will be putting a couple of these videos on every single week, and it would be usually helpful for you to look at them prior to coming to the meetings, so that if you can read the notes, you can look at the video and then come to the meeting somewhat prepared. I think it will make for much better discussions. It will make the meetings flow better in the way that I hope they flow, than if you just show up not having any idea what we're going to discuss or talk about that week. All right, over and out again.